So we're recording and we're deliberating. We're here at Terra Nova, Ellicott Mills, 27 Frederick Road. So we got two case numbers. We have the zoning special hearing case number of 21291, I believe, and then we have a development plan at 23013. We have, I believe, Mr. Gontram at the hearing kind of focused us on what was left as for zoning relief. I think it was just the parking variance issues that we were dealing with at that point in time, two different versions. And then we had oral arguments as to the development plan. And since then, just to make it a little more interesting, we now have motions concerning additional parties that were added by Mr. McCann, who basically just put in all basically effect of what he did is put some more names on his brief. So there's that. So gentlemen, do you want to quickly just address that issue quickly before we get into the meat of the game there? So both parties have cited a plethora of Board of Appeals rules, none of which are helpful. Because I can honestly say that this is something that's not contemplated within our rules. I think most of the rules are cited dealing with when attorneys can enter appearance for whom, this and that. I think the essence of what we have here is not whether or not Mr. McCann can represent them at any time, is who's allowed to be an additional party at a given time. I have dealt with this situation once before in a similar case, and that case too was hybrid in that it had both zoning relief and development plan situations going on. And I bring that up because the decision that we made in a previous matter was along those lines, because the procedural peculiarity I think that we deal with at the Board of Appeals is that our zoning hearings are de novo, even though they are at the same time an appellate sort of review, but not really a review. They're just an appellate step, but they're de novo. So basically the rules, the very liberal rules that apply of parties joining into a zoning type of hearing, really there's no written prohibition about when a person can come in and when they cannot. And in the history of this board, we have allowed things due to the very liberal standing rules of those feeling aggrieved to be in such hearings. The last case that we have this situation, we did make a distinction without citing any type of case, because I don't think there was any to find, but using more of a common sense, practical approach, is that in development plans, our role is record appeal. We are an appellate body that is reviewing a record. And in order to be part of that record and a party, we were more strict about a person would have to have been one of the original persons to have appealed the case to be part of the party. So in my mind here, the addition of the additional parties is permissible, I believe, in the zoning part of it, probably not permissible in the development part of it. But I must state that it does not matter factually to the board, because I can say for myself and probably most boards that the quantitative amount of support, meaning how many people are sitting on either side of the room, doesn't really factor into the legal strength of an argument. So it could be a sole petitioner or appellant against 1,000 people. If their argument is the best, that is the argument that should prevail. So I think the way I feel about this, even though it has no bearing, there's no additional evidence that is provided by these parties. There is no additional briefing that was attached to Mr. McCann that's doing arguments that are independent of the true appellant. So even if I were to be wrong, I see it's an error that has no effect on the factual finding of this board. Um, so that's where I am. Anybody would like to chime in? I've probably spoken too much about this preliminary issue, and we have a lot to talk about.
Well, I'm in the bottom line agreement with that. I just wanted to make a few points for the record. First of all, our rules are silent on this. We wrote the rules. We didn't contemplate this. I mean, this is an unusual situation where the people who actually wrote the rules are the ones trying to now interpret the rules. And our rules are simply silent on this. And so reference to the rules is not useful, number one. Number two, I'm not sure why this all has arisen. I'm not sure why this issue has arisen. I'm not sure why Mr. McCann has, why these other individuals have chosen to join this. I suspect it has to do with matters in the circuit court, frankly. But it certainly has no moment for us. I agree with that 100%. There could be 1 million people or one person. It's just at this stage of the game, completely irrelevant. I'm comfortable with the distinction between de novo and record review. Because just by, I mean, I wish the parties had been more, provided a little more information to us. I mean, we're kind of out here on a limb, so to speak, but you know, if my understanding is that if someone if you know, John Doe takes an appeal to the Maryland Appellate Court and that matter is pending, it's a review on the record, and people can't just join the appeal. If they have something to say, they could file an amicus brief or something like that, but they can't become a party to the appeal because it's on the record and they weren't part of the record. So I'm comfortable with the distinction that that you are making between a de novo appeal and a record appeal. So, and so at least for purposes of deciding whether someone can join a record appeal after the case has been argued in front of us, I think I just don't see why that should be permitted, really. That just seems to me to be, I don't know if it's obstructionist or I'm not sure what it is, but it feels real wrong at this stage. So I'm good with your distinction. I should add as well that there was no factual record before us with regard to the standing or non-standing of these additional individuals. I mean, there's stuff in people's filings, in their motions, but those aren't facts. And, you know, they're not verified, there's not affidavits, there's not nothing. So to the extent that I don't want to be understood as making any factual assessment, because there are no facts in the record for us to discuss or find or rule upon or base anything on. So that's my view.
Mr. Pennington, sir?
I tend to agree with both of you on this without belaboring it. But I do agree. The record appeal, the development plan, it was already, all the evidence was presented, testimony was presented. I mean, there's nothing, I don't understand why adding a party, I don't understand what that would accomplish at this point in time. And I do see the distinction between the de novo and the record appeal. I agree with both of you. At the end, I do agree with both of you.
All right. Well, we're moving on to the heart of the matter. So, gentlemen, you want to start with the zoning relief? And am I correct that we pretty much limited it now to the BCZR, the 409.6 A1 and 2, and the BCZR 409.8, the pervious pavement thing and the amount of parking spots. Is that what we have left in zoning?
I think so.
That's what I have.
Yes. So this is it was the variance for 293 spots instead of 349. And then the variance that kind of dealt with the pervious surface situation as well. These, we heard expert testimony from, we heard testimony from Mr. Bishkoff, Ms. Bishkoff, and Mr. Guckert, and this is a Cromwell situation. So we're looking at both factors, and I think Mr. Gontram brought up the fact that this is one of the few cases that we're not arguing about whether or not something's unique. The unique kind of hits us over the head in this one, because it is such a unique property, and all the unique situations that come up with the pre-existing property and where it's situated in the floodplain. So I think we're fine as to that. There was the practical difficulty discussion kind of comes back down to a discussion that we had in the first part of this case, with the original variance relief, looking at practical difficulty and trying to define it, and going back to the argument saying just because you can't do something doesn't make it practically difficult. And then I remember in the last case, I had done the deep dive into, was it Sorley, and then looking at the Horn book on how they described practical difficulty, which for my efforts was given right back to me in this brief. So I can't say I disagree, because it's what I said last time. So I'm going to be consistent.
That seems unfair when your own words are used, right? I mean,
But
that shouldn't be permitted, right?
Well, it made me feel better about my research. I was like, okay, well, it was believable. They gave it back to me. So I still, without getting into the serious deep dive that we have to, I find for the reasons that were spoken about the public benefit, and basically in this case, practical difficulty does exist. There could be no way around it due to the existing nature of what we have on the site. So I'm just going to defer to my previous rationale that was cited in Mr. Gontram's and Ms. Bussey's brief. So I'm gonna go with that. And gentlemen, I'll defer to the both of you.
I agree with you. I mean, I want you to go through the McLean solely factors that, as you said, you put forth in your last opinion, and we have to stay consistent. And I agree, the practical difficulty with the parking, 349 spaces required, and then going to I believe it was 283, based on the way that the structure is built, with the inability to have a parking garage underneath to have a lot of cars parked under there. And with the way the land's set up, I agree with you. I think there is practical difficulty.
Well, of course, I do too. I'm not sure where, I'm a little confused in my own mind about where the notion of shared parking applies. Is that more an issue with?
I believe it was the valet, with the restaurant, the valet parking.
Well, I know, but I mean, they were talking about.
I'm thinking of stacked parking. There was some stacked parking arguments.
Yeah. I'm not sure if that's part of the development plan question or if that's part of the variance, but I certainly think Cromwell is satisfied with regard to the variance. And I guess I want to say that I think the shared parking is relevant here. It doesn't violate the public interest in the slightest to have the number of spots be less than the BCCR would otherwise mandate. And you know, shared parking is a legitimate concept in the parking world, I guess. I must say, particularly impressed for this topic and for the development review part as well by the testimony of the developer himself. You know, I mean, this is a person who, you know, maintains skin in the game, as one witness said, and he doesn't want to have a development that has too little parking. That would be really a problem. And I think that is actually, at the end of the day, the most important consideration for me is, you know, his money is on the line here, and his money is settled on the notion that the 283 spots, or whatever that number is more than adequate for what is desired, or is adequate for what is desired, I should say, development wise. So I'm with the variance.
All right, so we're moving on to the development portion. The first issue, well, first of all, let's talk about the hearing that we reviewed. Again, this is a situation with an Elm Street analysis. We had the county agencies all coming out in support thereof. There was not expert testimony offered to refute any of the county findings, not to say that it is required. And I know Mr. McCann always makes that point that you could have all the testimony from the county and have nothing in opposition to it. But if the county testimony is erroneous, then it doesn't carry the day. It still has to make sense. So, but we did have the testimony from all and come through the county agencies. No expert testimony refuting it, though there was witness testimony from the community. The first issue that came through the planning office and Mr. McCann has brought up is the interpretation of the master plan compliance. And looking at the master plan situation, I believe, what is it? Is it 32.4.215 that perhaps that basically if there's a conflict, then it's supposed to go back to the planning board for some review. But first there has to be a determination that in fact there was a conflict of the master plan. The discussion is that there's a T3 transect, talks about different housing types and things of sorts, and the fact that of course that this industrial building that's going to be converted into more of a high density occupancy. There's the argument that it's not in keeping with the T3 transect. And then there's the competing argument that it is in keeping with the overall desire to retain and preserve historic structures and things of that sort. So that's the first thing I guess that we need to discuss. I found that the AOJ was tasked with making a determination whether or not there was a master plan conflict. What assists him in doing so is the recommendations and from the planning department that basically told them that, well, technically you could say there was, but they're saying that there wasn't because of the historical portion of it. There was testimony before the AOJ for him to make a determination whether or not there was a conflict. I believe that he made a determination that there was not. And I believe he had a substantial basis to do so based on information that he was provided. And I'm not willing to second guess that because I don't think his finding is erroneous or arbitrary and capricious on its face. So I think he made a factual determination on the information that he was provided from planning. So I'm not swayed that I have to overturn his finding of lack of a conflict and don't believe that it needs to be referred back to the planning board. So that's my thought on that one. So I'll defer to you, gentlemen.
Well, this whole case is fraught with complexity, but for me, the bottom line is master plan jurisprudence is weird. For these purposes, it is mandatory, I guess, okay, because it's a development plan and the statute says it has to comply with the master plan. On the other hand, the master plan, by its own words, is advisory. So that creates an automatic tension. And even more than the master plan being advisory, the T sections are absolutely advisory. They are not that, they, by their own language, if you look at their sections, they are guidance, they aren't property specific, they are, they're there as a tool and not much more than that. So, I mean, at the end of the day, I mean, this property just doesn't fit the T3 analysis. It's sui generis. It's highly unique. And I just don't, I mean, the T3 concept, transect concept, I just don't think even has any applicability here. I don't think that makes a conflict. I just it's just not relevant, actually, is the way I look at it. And I mean, Mr. Gontram and Ms. Bussey made a point in a footnote that if the T3 transect was required to be abided by here, there is nothing that could ever be done with this property, ever. I mean, it could never be developed because you can't, because there are so many limitations by reason of size and floodplain and all the rest, and you can't build anything else. You can't build a building here. You can only use the buildings that are there. So to say, okay, well, given that situation, it has to abide by the transect is, I mean, it's actually a little bit ludicrous if you stand back and look at it. Nothing could ever be done on this property. They talk about it as a taking. I'm not sure it's a taking, but it would lead to really illogical and absurd consequences. So I think it is not, if our review of the question is de novo because it's a question of law, I would rule that there is no master plan conflict. If our standard of review is deference to legal findings or factual findings or combined legal and factual findings made by the administrative law judge, then I would find that there is a substantial basis in the record for all of his factual and legal and combined factual and legal findings. So on that question, I also am with the chair on this.
Mr. Pennington, sir?
Yep. I am with both of you. The ALJ made a factual finding based on the testimony and evidence presented by the Department of Planning representative. And I don't see anything erroneous about the ALJ's finding. And then as Mr. Evans just pointed out, that even if you rely on the conflict with the master plan, I mean, it says right on page 1 of the master plan, which Mr. Gontram pointed out, that so you have a statute that says that the master plan shall be adhered to, but the master plan itself says it's advisory, basically. and that the policies and actions stated in the master plan are not mandatory and do not control or limit. So I agree with both of you.
I think it's important to note too that this structure was there before there was a master plan, I would say. So, so even when the T3 Transit was created, this place was already there.
Right.
So it in itself has been, its existence has been non-compliance, I guess you could say. I don't know if that makes a difference. All right, and all the ways we went about it, I think we are in compliance. We're all in agreement as to the master plan. The Mr. McCann brings up the issue for the pronouncement in the ALJ's opinion that due to bill number 2522, he was no longer going to look at traffic congestion because it had been taken out of the map as a failing intersection. And there was comparisons to two previous cases that showed that, you know, counties, the service maps are not controlling. You still can have testimony one way or the other. I think there was a distinction that was brought out, though, that in those cases you had expert testimony, often that was going against the basic maps, or the preclusion of testimony, a decision being made by a fact finder that they were not going to hear evidence on the issue because they believed that it was no longer relevant because of a map. That is not the case here. There was no prohibition of testimony. There was no exclusion of any witnesses before the ALJ. There actually was testimony that sort of dealt with traffic issues. That testimony, though being, I guess, asserted that it was for the zoning portion, kind of made it before us too. We had a little bit of traffic testimony in our hearing, in our de novo version of it, but this is looking back at that one. So maybe inartfully put by the ALJ as to the pronouncement, I believe, in fact, there was consideration of traffic. There was no preclusion. There was no expert who was ready to testify for the protestants to say XYZ that wasn't allowed to testify. Basically, the evidence is what it is. I don't think there has been any harm done by the inartful statement of the ALJ as to whether or not the controllingness of that bill. So what do you think, Mr. Evans, on that one?
Well, you know, he did sort of say he wasn't going to consider it, but then he did consider it in the back door, because what he did say is, well, while I can't sort of consider it as that, I am permitted to take into account questions of general safety, and traffic congestion is relevant to questions of general safety. And he found that there was nothing about the situation that would be unsafe. So he really did, after a fashion, consider it. Additionally, you know, this is a state road, as we heard, and at the end of the day, state roads has to weigh in on whether there's a safe and appropriately managed throughway here and roadway. And I mean, all of these questions have to be factored in by state roads, by the Highway Administration when it makes its ultimate determination about how everyone is going to deal with the road here. So I think it's not really much of an issue here, because I think it was dealt with implicitly by the ALJ and will be dealt with explicitly by state roads. So I don't see it as an impediment to this development plan.
Mr. Pennington, sir?
I agree with both of you, even though the ALJ did say I'm not permitted to consider traffic congestion. He, as Mr. Evans just said, he did really. Traffic safety is basically deals with traffic congestion. And then I guess we're combining the two the two issues, right? We have traffic volume was one of Mr. McCann's arguments, as well as state SHA issues. And as Mr. Evans said, I mean, State Highway Administration is not finished yet with this, so I don't see anything that rises to the level of any error from the ALJ in either of these two issues.
All right, so let's move on to the often confusing and all million statutory sites for floodplain waiver issues, which Mr. Evans always states that the statutory language that we have often is vague, contradictory, and confusing. And at heart, again, we have, the different definitions of development and whether or not this is development, that isn't development. In the ALJ's original opinion, he didn't deal with this issue too much. He did it on his motion to reconsider. The second opinion, he went through a bit more of an analysis. And basically, I was looking, I think it was 32.8.803, looking for the different reasons that, in fact, he felt that the waiver was appropriate without getting too deep into all his findings. I believe he articulated a factual basis of why he believed that it was appropriate. And I'm willing to defer to his factual findings as to that. And I'm not going to get too deep into it. I just have to flesh out an opinion, but I do defer to his factual findings as to the floodplains. Mr. Evans, do you have anything further on the floodplain issue?
I don't. I agree with you. I think we defer to his assessment, his determinations, and that's what our mandate is. And I mean, this project's in a floodplain.
Yeah.
Well, that's facticity here, but the developer's doing everything it appears possible to appropriately protect against issues associated with that, including making more pervious surfaces. So
yeah, in this case, actually, the argument is they're actually making remedial measures to make it better, and those remedial measures then count as development. So then you can't do it.
right.
It's kind of like the argument. That's so though a strict, and it's in Mr. McCann's credit, a strict constructionist view of that language might lead one in a vacuum to that conclusion. I just don't think it's practical, and it's kind of contrary to the common sense to do it that way. Mr. Pennington, sir?
I agree with both of you. I think it's pretty cut and dry to me. The ALJ made the findings, and I can't see anything in error.
All right. And then I think there's the final issue was the open space issue, the fee and lieu issue. We've had this argument on many occasions as to how explicit,
No, I don't think did Mr. McCann argue that?
He did.
He did.
Oh, okay. All right. Okay. I'm sorry.
He did. I think it was one of the 5 things that were there. He briefly mentioned it, and actually, Ms. Bussey and Mr. Gontram, I think they mentioned it too, because it was one of the 5 things that were argued on the record. I mean, I have no problem with the AHL's finding as to that issue. Again, I understand that the strict constructionist view of that, but in practice, what is done is what is often done, and I believe it was appropriate for the AOJ to find in that fashion. Mr. Evans, do you have any further thoughts as to that?
I agree with that.
Right. Mr. Pennington, sir?
I agree.
All right. Mr. Pennington, you keeping score? Am I missing anything?
I have all 5 issues covered.
Okay. All right. So we went through. Mr. Evans, did you have anything final that we did not get to from the briefs?
No, I'm good with it. I you know, no, I'm good with it.
All right, well, I guess we are in agreement. I believe there were in the original findings of the development plan, I believe there was conditions, of course. I think we defer to those conditions as part of any
Right.
future order that we were to pen. All right, well then, we are all in agreement, and I guess we are moving on.
Yes,
All right.
I would hope that this would end this matter. But I guess one can always hope, huh?
All right. All right, gentlemen, it was fantastic seeing you this morning.
Yeah.
All right. We're
Great
signing off.
seeing you all.
Appreciate it. Mhm. Bye-bye.